Friday. My name is Megan Conyers. I'm the Executive Vice President of the Florida Customs Brokers and Forwarders Association, and I am thrilled to have two fantastic speakers, extremely knowledgeable experts for you today. We've been talking about export controls, and everybody's been kind of dancing around the topic all year. So we're finally putting that plane on the ground and letting you learn what to expect as we move forward and how to prepare yourself in the face of potential issues. So we're going to have two speakers today. The first one's going to be Mr. Peter Quinter, trade attorney, and he's the chair of the Customs and International Trade Law Group at Gray Robinson. You've got his contact information. Please reach out to Peter for anything. You guys know how accessible he is if you've ever had to reach out to him. But he is thrilled to be able to walk us through. And then after that, we're going to hear from Mr. Rob Lutzi, who is former special agent in charge at BIS and now is consulting on his own and in the newly found freedom of the consulting world. So, gentlemen, I know we have a lot of information to run over. So, Peter, I will turn it over to you.
Sounds good. Thanks very much. So you'll advance the slides?
I will.
Okay. All right. So there's a picture of me in my downtown Miami office. As you probably all know, I'm a chair of our U.S. Customs and International Trade Law Group, Gray Robinson Law Firm, 300 lawyers throughout the state of Florida, plus Washington, D.C. First 5 years as an attorney for U.S. Customs Service at that time, now called U.S. Customs Border Protection, and for the last 26 years representing the trade in various aspects. Today, we're going to talk about export controls, and let's go to the next slide. Lots of agencies involved in this export control area. It can get confusing for exporters, carriers, freight forwarders, anybody involved in the international supply chain, because all of the agencies involved, just look at the acronyms. If you can take a test, anybody who knows all 8 would be great. Office of Foreign Assets Control, we could have a day-long seminar on that. The embargoes and sanctions like Cuba. BIS, Bureau of Industry and Security, that's where Rob gets involved as a former special agent in charge for BIS here in Florida. And that's the U.S. Department of Commerce. We're going to talk a lot about that. TSA, you should all know. CBP, of course, you know. Census Bureau, I'm going to get into that quite a bunch quickly when we talk about the AES and EEI. HSI, Homeland Security Investigations, State Department's DDTC, Director of Defense Trade Controls, and even the Federal Maritime Commission, all involved as federal law enforcement agencies on export controls in one way or another. Next slide. Okay. The 3 that you mostly hear about are the DDTC with the State Department. They regulate ITAR, International Traffic in Arms Regulations. We're going to focus today on the BIS, Export Administration Regulations, and not today on OFAC's regulations. Next slide. Okay, I've been talking to FCBF and its members for a few years now on the importance of compliance with the automated export system, electronic export information, getting it done accurately and timely, because I see the consequences of not doing so. You're going to hear and see in this PowerPoint the consequences of delayed exports because customs wants to look at the cargo, seizures of merchandise for false or inaccurate EEI filings, penalties against exporters or freight forwarders for inaccurate or untimely filings, and criminal prosecutions that result from investigation that started with someone looking at a suspicious EEI filing. All right, next slide. All right, as you probably all know, it's been several years now. EEI is required for any cargo exported value over $2,500, plus whenever there's a certain licenses required from state commerce or OFAC. There's no excuse, $2,500. If it's over $2,500, you've got to file the AES and accurate EEI on time. Next slide. Okay, what to file? It's so easy to make a mistake. Why? Because there's so many data points that every forwarder or exporter has to file with U.S. Customs and Border Protection. Look at all of these mandatory data elements. Lots of them. If just one of those is wrong, if the related party indicator is wrong, the port of export was wrong because there was a sudden change from Port Miami to Port Everglades, or the destination was changed, the port of destination was changed. Any one of those can result in the problem for the exporter. Next slide. In addition to the mandatory elements, you have all these conditional data elements. So there may be an FTZ involved, there may be a motor vehicle. So look at 10, 11, and 12. If any of the, let's say the VIN number is inaccurate, that's a violation, could result in the seizure of the cargo. And let's keep going. Next slide. All right, so obviously you file electronically, but when I get it, I like to print out everything. And this is what a printout of the EEI would look like. This is an actual document that I have from a client, which of course I've sanitized. And all the information of the data points that I just mentioned are listed in this slide and the next couple of slides.
Hey, Peter.
Yeah.
Sorry, Peter and I agreed we were going to interject on each other's things. I just wanted to point out for the AES and EEI stuff, a lot of times people will think of just CBP reviewing that. Actually, BIS and all the agents have access to all those same systems granted by DHS. So we review that stuff on a daily basis. And prior to my retirement, I set up the first national working group. It's the Export Enforcement National Security Working Group, where CBP actually sits in my former office. They have their own office, and we have a team of CBP agents, and we will literally sit there and together review all this information, review all these red flag indicators, review all this on a daily basis. I say we, I correct. For the agents will, and they review all this information routinely. And now with CBP literally sitting in our office on a full-time basis, it's just exasperated, and it's more routine than ever.
So Rob, I want to emphasize more what you just said. Are the agents, CBP or BIS, looking at the data prior to the exportation of the cargo or only after the exportation of the cargo?
All the above. They are routinely, every single day, agents will come in, access AES, and start scanning for stuff. CBP start scanning for all the stuff that was listed in the two previous slides. They look for that, they look for discrepancy, and it gets flagged. Right. And then it gets looked at from there.
Exactly. So I want to make sure people are totally aware of this. If any of the information is inaccurate or incomplete, that's a red flag, and the agents will can select the shipment for examination. It just causes at least a delay. You might even miss the sailing of the cargo. So that's why I'm trying to emphasize, make sure that the information is timely filed and accurately filed. Okay, so next slide. So here you have a list of items. Now this is important. This is a common mistake where forwarders or exporters will group different cargo in the same line, and that's not appropriate. The way to file the EEI is just like on a customs entry form with the line entries. You separate the different types of cargo by whatever the cargo is. So ink cartridges are separate than keyboards that are separate from a red switch, from a monitor. And then you put the accurate value of that merchandise and the quantity, et cetera. Don't group them, because that can be a telltale sign for the government thinks that you're trying to hide something. All right, next slide. All right, just keep going, one more slide. All right, so this is a typical CBP detention notice, a real accurate document. Here we have 12 pallets that CBP has decided to detain, and the reason cited is quantity verification. Again, in the EEI, you're going to identify the weight and the number of whatever it is being shipped. For whatever reason, customs didn't think it was accurate, so they selected this shipment for detention and examination.
And where detentions, here's the difference with BIS detentions. Our timeline is pretty much indefinite. I know CBP's clock starts a lot faster, but our detentions could be a result of an investigation or something routine. So the standard 10, 15, 30 days has been, months, almost years on certain cargo if there's an active investigation.
And here's where it gets even more frustrating. Let's say, Rob, a shipment is selected by BIS for examination. Are you obligated to tell the exporter why you're examining that shipment?
No obligation. And I'll explain that further in my slides, but there's new export enforcement authorities that are far-reaching, and there's no obligation to tell why. It could be routine. They could tell you that it's routine. They're not going to tell you we have an active investigation on this company, on this shipment. Let us look at it. You're going to get generic requests.
Right. Okay, next slide, Megan. Okay, so here's a notice of seizure. Many of you either have never seen a notice of seizure or maybe you have. I've handled over 3,000 fines, penalties, and forfeitures, seizures, penalties, liquid damage claims with FPNF, fines, penalties, and forfeitures, CBP, throughout their 34 offices in the United States over the last 26 years. Pretty darn familiar with the system. This is a generic seizure notice for export violations. There's a list of what's been seized. The value is, in this case, $647,567, high value. And the citation of the explanation for the seizure is there. It says the property was seized and subject to forfeiture for exportation contrary to law, 18 U.S.C. 554, export smuggling, 22 U.S.C. 401, illegal exportation, and then always the common 15 CFR 30 point something, failure to correct electronic export information and incorrect shipment value. Very common scenario. It's amazing how many shipments have the incorrect value on them, where CBP looks at it and says, whether it's a car, a plane, general cargo, they have a sense of what the value should be. So if you undervalue it, it's just a way for customs to find an excuse to stop and examine your shipment. And maybe it leads to something worse than that. So try and be as accurate as you can. And what happens? So let's go the options. Here's a notice of seizure. You see option number 1, petition. When you get a notice of seizure, you have 30 days to file a petition with CBP. Next slide. The other options are an offer in compromise, when you say, listen, here's $50 or $5,000 or $500,000 customs, release my cargo. Number 3, you can abandon the cargo. Number 4, you can file a claim and cost bond. Claim is, this is my cargo. The cost bond is 10% of the value of the merchandise, or a maximum of $5,000. That's refundable. When the claim and cost bond is filed with the fine,
Peter, I think we lost your audio for a second.
Oh, typically we negotiate the resolution of the seized property with the legal office of U.S. Customs. All right, next slide. And one more slide. Okay, this is the election of proceedings form that you always get with a seizure notice. You have to check box 1, sign and date it, or your lawyer will sign and date it and submit it with the petition to CBP. Next slide. Okay, so here's a typical petition. You've seen what a seizure notice looks like. Now, the first time you're seeing one of my petitions. Obviously, I've sanitized it again. So what happened in this situation? This is computers seized by CBP, which attempted to be exported. The value is $1,122,218, and it's the same citations, legal citations for the violation, the 15 CFR. This is all the AES, EEI stuff. And I summarize the facts very simply, where I say petitioner submitted the EEI to CBP through ACE. Unfortunately, the EEI did not match the actual inventory in the subject container, and the shipment was seized by customs. All right, next slide. This is an unfortunate situation. I would guess if customs really wanted to examine every single container and match it against the EEI, I would say more often than not, they would find some sort of discrepancy. Unfortunately, the FPNF handbook mitigation guidelines. So I'm quoting the guidelines back to customs, and I'm using the guidelines to persuade CBP to release the shipment, hopefully without any kind of a penalty. All right, next slide. And here's the 15 CFR 30.71, which you always see, and talks about false or misleading information, and $10,000 per violation, which is why you typically see, if it's a standard EEI violation, a $10,000 penalty. Next slide.
And on top of that, Peter, BIS can come behind CBP or in conjunction with CBP and pile onto these same civil charges, which I'll get into
Absolutely.
later.
Absolutely. Absolutely. So we're going to see an example of that. So here's a very typical, this is your standard CBP $10,000 penalty for an AES violation, where it says something was supposed to go to Uruguay. The EEI was filed untimely. It says here the EEI was due on February 15th, 2020, but was not filed until March 2nd, 2020, 16 days late. It's an automatic $10,000 penalty. So you have 30 days to file a petition with CBP and get that mitigated, hopefully to zero. If you do everything right, whether it's through you or your attorney, typically you can get these down as low as $500 or $1,000, which is a lot better than 10,000. All right, next slide. Okay, this is the second page of the penalty. Next slide. Okay, so there's another situation where CBP detained merchandise for license determination. And this involved actually BIS. Maybe, Rob, you're going to be familiar with this one. This was a crane, believe it or not, something called a military crane that was being exported from the United States to Latin America. And the exporter did not have a license from the Commerce Department because he didn't think he needed one. He never heard of something called a military crane, or so Customs seized it. And no, Customs detained it. I got involved right away before it was seized, persuaded the BIS special agent not to have Customs seize it, to allow me to go to the BIS, submit a license application, get the license, submit that to Customs and BIS, and then allow the cargo to proceed for export. So that's what next slide. All right, so it was seized. It was a penalty was issued by CBP for the value of the merchandise, $14,194. I filed the petition. Petition was granted because I filed the license along with the petition. And since the merchandise was only detained and not seized, the merchandise was allowed to be exported. Next slide.
You know, and this goes back to the working group that I established, you know, that was a routine screening that happened by the CBP officer that sits in the office, walks next door to the very adjoining office to the BIS agent and says, look what I found. Yeah. BIS agent, all right, let's go to the port, check things out, check the paperwork, look at everything, see everything's up to speed. And those examples, you know, where they found issues.
Yep. And that happens
very common
all over the place. People don't realize, you know, people think when it comes to customs, it's mostly import, maybe, but nowadays, if I'm allocating my time, I'm probably spending 60% of my time on import situations and 40% on exports. 5 years ago, I was only spending about 20% on exports. So I'm spending a lot more time on export situations because BIS is more aggressive, I think, on export matters. Okay, so let's skip this slide. This talks about penalties. So we mentioned $10,000. Here's the CBP penalty notice for the military crane that was fortunately never seized and has now been released and shipped. Next slide. Okay, Bob's going to get into this later, but when we talk about situations involving the Bureau of Industry and Security, BIS, Commerce, they can take all kinds of actions against companies. A no action letter, a warning letter, administrative enforcement through a charging letter, penalties, and potential criminal investigation. So Rob will get into this later. Next slide. Okay, here's a typical warning letter. Rob is going to show us other examples. The government says, and this is very recent, November 3rd, 2020, so very recent. Next slide. I think, Rob, you did not sign something. Okay. Alan is, as you know, acting special agent in charge. So it's a familiar letter, huh? So this is typical. What we get is a warning letter where the exporters warned, don't do this again, because next time we will take more serious action against the exporter.
So let me interject there too. The Alan Berkowitz, acting special agent in charge. We came up in OEE together. We were in OEE together our entire careers. He's a best friend of mine, and he is now the acting special agent in charge. So I now have that ability and that connection for you guys to be that conduit between the new acting special agent in charge and any issues you might have. So I just kind of want to point that out. The relationships continue and that sort of offers you guys those opportunities as a bridge to communicate with enforcement without actually having to, dealing with them directly.
Right. So getting back to the introduction, Rob and I have known each other, I don't know, at least 10 years. And it's very interesting, the relationship, because he was always the special agent in charge for Office of Export Enforcement here in Florida for all those years. So our cases, we were sort of on the different sides of the table. And now that he's free as a private consultant, we're on the same side of the table. So great guy to know with great connections, and he knows everybody within BIS, and it can make a difference if you know.
Yeah, and that's interesting. I'll add to that is now I'm on your side. I helped the government for over 23 years, and now I'm ready to go out there and help industry.
There you go. There you go. All right, next slide, Megan. Okay, so obviously on the import, I just want to make sure we mention this. Just like on the import side and exports, whether it's bills of lading, airway bills, et cetera, you got to keep all those documents for 5 years. You can keep them in paper, you can keep them electronically. They have to be accessible to whether it's HSI, CBP, or BIS upon request. And if you don't have the documents, that's an automatic violation. Next slide. And maybe Rob will get into what kind of documents they look for and why they look for documents, and why do they especially like going to freight forwarders to get those documents. But I also want to point out in the census regulations, we talked so far about penalties and seizures. We haven't talked criminal yet, but the law here allows for not only a $10,000 penalty, but imprisonment for not more than 5 years or both per violation. Get serious. That's why the special agents or criminal investigators for BIS and HSI are very interested in export violations. Next slide. And we just want to, all right, so most of you, I hope, have never seen a criminal indictment. I was a special counsel and technical advisor to a law firm here in Miami that had a case in Jacksonville. Basically, boats were being exported from the United States to Hong Kong, and the allegation by the government was the real destination was not Hong Kong, it was People's Republic of China, and these items would have needed either would not have been allowed to go to China or needed a dual use license from the Commerce Department to go to China. Next slide. So in the indictment, there are 6 charges or counts, and there are 2 of the counts specifically allege false statements to the government in filing the EEI. Next slide. All right, this is exact quotes from the counts from the criminal indictment. And when I talk about being accurate in filing the EEI, the freight forwarder has got to be sure that information is accurate. And if you're questioning it, ask your exporter to verify the information. Don't guess, and double check, because even one data point that could be wrong, the value, the destination, et cetera, execution. It's what's happened here. Next slide. Okay, so this is the agreement. This is some of the individuals who were involved. Next slide. And this is the essence of the violation, that the grand jury has concluded that these people specifically knew they caused the submission of false and misleading export information through an SED and the AES in violation of 13 U.S.C., et cetera. Fraudulently and knowingly attempting to export merchandise. This is it. This is all from EEI, from really some smart CBP officer or agent, and probably a BIS agent who saw something that was wrong. And it took a year of investigation and another year of prosecution. And the individuals recently pled guilty and will be sentenced next month to time in prison. Next slide. Okay, again, this is false export information, count 5. Talks all about the AES requirements. And I think the last slide next. One more slide. There I am again. All right, so in summary, I went 20 something minutes, but I wanted to emphasize the importance of your EEI filing for freight forwarders and exporters. The BIS is out there, CBP is out there, they're looking at your to verify the information that is accurate. And if it's not, there are consequences. All right, Rob, it's all yours. Talk to you in a minute.
Right. I mean, first and foremost, let me thank FCBF and Peter Quinter with Gray Robinson for letting me join in on this. This is going to be a great asset for me and everyone on this webinar. So I'm very appreciative. A little background on me. Originally from the Washington, D.C. area, I spent almost half my life and my entire career with BIS. And I was a field agent in Washington, D.C., and their field office came down to Florida for 5 years to be a field agent working cases. I had the opportunity to go back to Washington, D.C., become the assistant special agent in charge of that field office. I don't know if it was wrong place, right time, or however it worked, but I ended up skipping over the special agent in charge and becoming the assistant director for all the investigative offices in the entire country at headquarters. Worked really hard at that. Somehow skipped over the director and became the acting deputy assistant secretary, which I was in charge of all the directors in the entire country. And at that point, I had the distinct honor of being the only BIS agent to hold every position in BIS, whether permanent or acting. So I kind of take pride in that and the wealth of knowledge that I got out of those years. And now I'm at your disposal, and so is all of that experience after starting my consulting firm. Next slide. If you don't know who we are, so we're going to have an agenda. I'm going to keep it simple in 6 sections about who we are. Some key acronyms you'll see that are important for today's agenda. Very important, hot off the press information. The ink isn't even dry on some Federal Register information that happened less than 48 hours ago. I'm going to go over the criminal administrative portions, list of checks, vulnerabilities that U.S. freight forwarders may face based on my experience, and then some inspections and case examples. Okay, next slide. Who is BIS? So the Bureau of Industry and Security is the principal agency involved in enforcing export controls. It's divided into 2 groups, enforcement and analysis. And essentially enforcement has 3 divisions under it, which is export enforcement, enforcement analysis. They are our intel division. They do all the intelligence gathering related to exports, and then the anti-boycott compliance division. And on the other side, which we commonly refer to as the licensing side, that's export administration. They're dealing with all the licensing, the classification, and so forth. And then under them is exporter services, who handles all of the education and seminars and everything you see, the website data and so forth. Next slide. Export enforcement, our mission, right at the front, national security, homeland security, and foreign policy. That is our #1 focus and goal. We enforce the export administration regulations, again, detecting and preventing illegal exports, investigate and prosecute, which hopefully I will keep you guys out of any trouble and ever having to deal with that. And then also importantly is the partnering and educating industry. We're going to prevent illegal transactions. Some of the worst caveats or add-ons to the penalties is the negative publicity that comes along with that. It can crush a company, and that lingers for a while, and then we'll, again, fines, penalties, imprisonment. This is 100%, OEE is 100% into export enforcement, and that's it. All the other big name 3-letter agencies, they do all kinds of other investigations. They have all kinds of other divisions. We exclusively, or OEE exclusively, does export controls, therefore, by far, having the subject matter expertise. Next slide. These are the field offices, depending on who called in, if it's mostly Floridians. The Miami field office covers Florida, Georgia, Alabama, and Mississippi. And prior to retirement, I opened up an Atlanta RAC office, and they focused on the Georgia, Alabama, Mississippi area. And then also under the Miami field office is Puerto Rico and the Virgin Islands. Those little deviations of those lines segregating the different states are the states that are controlled by that particular field office. They're averaging probably 8 to 10 agents per field office. So that's a pretty big geographical area for that many agents to handle. But in addition to that, we sit in various field offices. We have one-man offices in FBI and DCIS in Texas, as well as overseas locations. Next slide. Sorry, bear with me on the we part. I'm still adjusting to retirement and need to say they. Next slide. All right. So for today's discussion, these are the important acronyms I want you guys to be familiar with. The CCL, which is the Commerce Control List. Those are the items that are controlled by commerce. The Export Administration Regulations. Again, those are the regulations that we enforce. And these are for dual use items, which basically have a civilian and military application if they fall under the Export Administration Regulations or the EAR. The ECR, the Export Control Reform, that took place for many, many, many years. I dealt with it on a daily basis at headquarters, where there was a consolidation of basically state-controlled military items and commerce-controlled items, and they redid all the lists, they redid all the items under control, and they came up with new lists, basically to benefit industry, so there's less licensing requirements and restrictions on items that really should be controlled under dual use. ECRA, ECRA, is the Export Control Reform Act. That is the latest regulations and authorities that were granted to OEE. Therefore, that act gave OEE and BIS their permanent law enforcement authority, because for years and years and years, the Export Administration Act, and you see the other acronym IEPA, they would expire, they get renewed, expire and get renewed. ECRA is now formalized and made permanent the law enforcement authorities of OEE. Next slide. And the last one is the Export Control Classification Number, which you as freight forwarders see all the time. But just in case there's somebody new to this, it's the 5-character alphanumeric key that's used by the Commerce Control List. And you can see in the breakdown in the bottom right corner there that the 3 stands for electronics, which is the group to the left, the chart to the left. The A is the product groups, and then the 001, that's the subcategories within the Commerce Control List. And as Peter mentioned, there's stuff in here that is 4 or 5 days worth of seminars to understand those classifications, but I at least wanted you to be aware of what it was when we're discussing it in today's seminar. Next. All right, this is the hot off the press. Next slide. The Federal Register 73411 has just been published as of Wednesday evening or Wednesday afternoon, titled BIS amends the EAR to reflect enforcement authorities and updates certain provisions. Overseas Investigative Authority, that's a huge one. Now OEE and BIS have agents or have the ability to conduct investigations overseas, where typically that was a conjunction with HSI and FBI. Now OEE has the authority to go out there and do their own investigations, independent, and conduct those investigations worldwide. For you, as the freight forwarders or anyone else dialed in today, this is important in the highlights. Places of inspection, search, and detention in the highlighted area, but not limited to the borders of the United States, all ports of exit, the premises of freight forwarders, bonded warehouse, forward zones, et cetera, et cetera. We always coordinate, and we still will, or OEE still will, coordinate with CBP when going to the port. It's just that common courtesy. But OEE does not have to now. They can go to the ports, do all these inspections on their own. And that, in the next section, applies to conveyances too. This is a humongous change for OEE. This includes the borders of the United States and all ports of exit. Again, now OEE agents can go out, inspect, search, and detain conveyances without any assistance or authorization from any other agency. So it's a huge win for the department, I should say. And again, the agents have those relationships with each other, and CBP and HSI, that coordination I think will continue. But just so you know, if independently you see a BIS agent show up, they do have the authority to do all those things on their own now. Next slide. All right, I'm going to get into the criminal and admin violations. These are how are you going to know if what avenue we're pursuing? What is the government's path? For criminal, it has to be willful and specific intent to violate the law. It's very specific. You're going to have to really prove that, and as Peter showed in the example indictments and so forth. probable cause and all that stuff will be demonstrated and spelled out, but willfulness and specific intent. Whereas the civil or administrative penalties are on a strict liability standard. Basically, it just had to happen. You just had to mess up. You just had to omit. The act occurred, the export occurred in violation. It literally just had to take place. And that is the standard for civil administrative. And there's a 5-year statute of limitation on those investigations.
Rob, let me interrupt you and ask a question. A typical kind of situation where an agent appears at a freight forwarder's office or an exporter's office, asks for the manager or president, and the president or manager comes out and the agent says, we're here to conduct an investigation. Is the agent obligated to say it's a criminal investigation, it's an administrative inquiry, who the targets of the investigation are? What are they obligated to tell the
There's no obligation, especially not the targets, unless they are soliciting the help of the freight forwarder. You're generally going to get broader inquiries on specific countries or specific end users or so forth. And then that scope will typically get narrowed down to fine tune what the agents are specifically looking for in an investigation. But the obligation to tell you what exactly we're looking at is not there. In fact, it's typically more generic in order to prevent that information getting out.
Right.
Because we don't know, agents don't know if the freight forwarder and the actual target have a relationship, or is there a conspiracy between the two? You don't know at that point. So it's typically very generic when they're doing that stuff. Next slide. Awful criminal charges you can face. There are so many now. They were really narrowed down many years ago, but now we're seeing easily the 18 U.S.C. 371 and 18 U.S.C. 554 and 13 U.S.C. 305. Those three are very common criminal charges that can be brought as export violations. So you won't think of just EAR violations. They can charge criminally conspiracy, smuggling penalties, wire fraud, money laundering, and false statements especially. And in the next slide, I'll show you administratively, it's even more exasperated. Look at all those charges and violations that they can bring. And the administrative ones, frankly, are extremely easy to prove. Causing, aiding, or abetting. I mean, it literally just had to be part of the export. Engaging in prohibited conduct. I mean, these are so easy. Misrepresentation and concealment of the facts. I mean, you didn't tell the truth on an EEI. Failure to comply with record keeping and reporting. That one's slam dunk. You didn't keep your stuff for that one shipment. It's an easy charge. Now, will you get charged for something, as simple? That's what you and the investigators will work out together. But wait, as you see this next slide, why you don't want to do it. Look at those criminal penalties. $1 million or 20 years in prison for the ECRA charges. So that's why when you saw those other criminal charges, they typically carry a 5-year penalty criminally. So you don't see as many of the actual ECRA charges, because 20-year prison sentence, you have no shot at getting someone to plea on that type of charge. It's just too risky. So these other charges are able to be put in there to sort of lessen the amount of jail time that somebody would face. But 1 million and up to 20 years. Administratively now, we're up to $300,000, or twice the value of the export. $300,000 for messing up. Now, my job and Peter's job is to come in there and say, yes, it was a mistake, and we're sorry, and it was a computer glitch or a new person error, whatever it is. And that will typically result in what you see on there as a warning letter. Warning letters are extremely common. If you get one, my advice is really don't try and refute it, because it's literally the lowest level, besides a no action letter, that you will get from an OE agent. And it's just a slap on the wrist. It's saying, hey, we know about it, you know about it, fix the problem. Here's your warning. Don't let it happen again. And yes, you can get more than one warning letter. big companies and small companies I've seen get them 10, 11 warning letters for simple mistakes. But, you know, the more you get, obviously, those warning letters can be used, you know, against you in a case that comes up later. To level the playing field, there's the denial of export privileges. So let's say a huge corporation comes in and they're like, I don't mind paying $3, $4, $5, $6 million in administrative penalties because I'm going to make $80 million or $150 million on this transaction. So let's take that chance, and if we get an administrative penalty, it's worth it because we're going to make a profit. Well, BIS and OE can come in and deny your export privileges. Now you slap that denial on a huge corporate. Let's say I'm just picking FedEx because they're just the frequency. You deny FedEx their export privilege, you're knocking out 50% of their business, and that can last up to 10 years. So the denial of export privilege is a very powerful tool, but it also levels the playing field for the smaller businesses keeping up with the larger ones who, you know, have all those resources to them. And then they can also come in and temporarily deny export privileges for 180 days. And that we see that very common in these exports. So huge numbers there to pay attention to and be aware of, especially if you didn't even know BIS existed before this webinar. Next slide. In addition to the penalties put in there and all the fines, a lot of times they'll suspend the penalties, and they'll do it based on your inability to pay. Of course, that has to be proven with your tax returns, or your cooperation. But a lot of times penalties will be suspended, and they will take that suspension money and they will require you to have, as I see there in the highlighted, hire an unaffiliated third-party consultant, knock on wood, and to conduct one or more external audits of the company's compliance. So you're seeing more and more now where law firms and consultants are coming in and auditing companies for a set amount of time. Every transaction, or coming in once a month and auditing all their transactions to see if they're in compliance. And if you're not, all that suspended money, the millions of dollars, is going to be, it's almost like a probation. You're going to be liable for all that money if you mess up. So a lot of that suspended money that you normally would have paid could have been used for that compliance audit, but you're seeing a lot more of these audits happening in bigger and smaller companies. Next slide. Here's where you can get ahead of the game: voluntary self-disclosures. It's where you feel that you violated the EAR, and you want to tell the U.S. Department of Commerce and BIS that you found some mistakes, you did your own audit, and you want to essentially say, hey, I'm disclosing these violations, and please have mercy on me. That goes directly to the Director of Office of Export Enforcement, and there's a whole process for that. But it is a strong mitigating factor when considering administrative violations, because you're essentially policing yourself. You're coming forward and say, hey, we did an audit, we found a mistake, or we bought a company, we did an audit, and we found a bunch of stuff that they did wrong that we didn't know about. You can voluntarily self-disclose that information, and that is just great weight. Now, typically, when the agents get a voluntary self-disclosure, it is not probably the top priority of their caseload, especially if they're working criminal investigations, and this gets piled in. But every self-disclosure still has to get investigated by an agent. So don't be surprised if you're contacted or your lawyer is contacted by an agent, because they still have to follow up on the facts of the VSD, the requirements. And if an agent finds the violation before you voluntarily self-disclose, or before you admit it, it doesn't count as voluntary self-disclosure. So that's very important, that you want to divulge that information before the agent finds it first, because then it won't count.
So Rob, let me add to that, because I've seen this many times. So let's say a company approaches a lawyer and says, listen, we have a problem. 2 years ago, we exported some merchandise, didn't have a license. It went to the wrong party, and we need to disclose that to the Commerce Department. Please file a VSD. The lawyer prepares and files a VSD for that transaction, and they're covered. The agent asks some questions, and it turns out there are 2 other shipments that were sent to the wrong party without a license. Would the VSD cover those 2 other shipments?
It would technically not cover those other 2.
Right.
But, and I say but, typically, and I cannot stress this enough, to develop that relationship with the local field office or your attorney or myself, developing that relationship to where, hey, we did a further examination. We did find 2 more. We'd like to voluntarily self-disclose 2 more. Is that an option? And you might be able to work that out with the current management staff. I don't, again, that you guys are in this scenario, you're coming forward and say, hey, I did something wrong. I found 2 more. I did something wrong. If the agent finds it during the process, technically it doesn't count. But again, work with your attorney to have them work with the field office, and better things have happened. And typically, unofficially, most voluntary self-disclosures have been resulting in a warning letter. The workload facing the agents and the chief counsel's office at DC that would handle all these is astronomical. And you have to prioritize. You have to prioritize what are the mission critical items, and do I have time beyond the basic investigation to pursue this. In very rare occasions, you will have people lie on a VSD, and then it will go criminal or administrative.
I've seen that. So let's just talk practically. An export violation has occurred. Whether it's a VSD or not, a charging letter has been issued by BIS. The chief counsel attorney for BIS is identified in that letter, and there is negotiations between the violator and the chief counsel. How is the agent involved in that settlement discussions?
They're involved from the minute they submit the VSD, report on their findings. Like I said, they have to investigate it anyway, and they submit their report if there's a warning letter or whatever issued to the agent is involved through the entire process. They made it very transparent for both the field offices and industry in order to have that inclusion. And in a lot of cases, the agent can say, mitigating or aggravating wise, this is what I found. And if the chief counsel's office says, we don't want to pursue, let's say, more than $5,000 in penalties, do you, field office X or agent X, concur with this conclusion? And that discussion would take place. So they're involved in the process all the way up until it goes before the review board, the administrative case review board, who makes the final decision. And that's done by the deputy assistant secretary and the assistant secretary ultimately.
Right. So I want to make sure everybody on this video knows it may be the chief counsel attorney assigned to the case by BIS in Washington that the violator is directly dealing with, but that attorney will rely upon the advice and recommendation of the special agent who investigated the case as to whether to settle, and if so, what the settlement terms will be. So always.
And a lot of times the agent will, I don't want to say lose isn't the right word, but the industry will benefit from the settlement, despite the agent, let's say, wanting to say, no, I want it to be much, much more. And then the lawyers will do their part to get it down. And then ultimately, like I said, the review board makes a decision. But if there's immediate concurrence by the field office and the agent, then it's typically, agreed upon.
Right.
Next slide. All right, these are the red flags, and these are some of the freight forwarder vulnerabilities that I identified, briefly in my 23 years experience. But as far as lists to check go, and these are all on the BIS website, the denied persons list. These are all lists that we as agents check, and you as freight forwarders or industry need to check routinely, all the time, religiously. And it's a list of individuals and entities that have been denied export privileges. You cannot export to these people. You cannot export to the people on this, do business with them, and be involved in exports. Consider it like a blacklist. They are denied any privileges involving exports, and that is on the website. And that's just an example screenshot of what it looks like. So you can easily search that. Next slide. This is probably the next one would be the entities list. There's an example straight from the regulations. These are foreign parties that are prohibited from receiving the goods. And I chose Iran and different groups in there. you'll see under the license review policy, presumption of denial. So that's so if you have an entities list recipient, you can technically apply for a license. Now, will you get that license? You can see on the chart there for Iran, there's a presumption of denial all the way down the chart. So the odds of you getting an export license to send to this entity is very rare. And you do not, as a foreign entity, want to be on this list. It's not impossible, but let's just say it's very difficult. But this is another list, and as a freight forwarder, you better not have them as a final end user unless there's a specific license listed in the EEI and it's authorized to go. Next list. This is the unverified list, and these parties have been unable to be verified by agents in we have agents overseas. They're called ECOs, Export and Compliance Officers. So we have agents overseas that do end use checks and pre-license checks, and they will go out and see if certain items went to certain addresses that they said they were going to. And if they are unable to locate those addresses or locate those entities, they go on the unverified list. And that should be a red flag that if they're on that list, you should not be exporting to these companies because they're probably fake, or they're open for business just to receive those one set of goods and then they disappeared, or the particular government won't even let us access to that particular entity in that country. Do not export to them. Next slide. All right, you're probably, how on earth am I going to check all these lists all the time for all these exporters? I'm a busy person. I got to get this stuff out of my warehouse. How am I going to check all this? Well, they provided software in there, and it's on the BIS website, or you can find it anywhere by Googling it. It's a consolidated screening list, and those lists will check them all at once. You can plug a company in, and they'll check all those different entities list, as well as State Department too, and they will check them all, and it's a nice consolidated source to put your information into and look at those lists instead of going one by one. So don't be scared of pulling your hair out yet. There is a consolidated way to do it. And there's other private sector software out there, I believe,
yes,
that will take it even further. Next slide. All right, vulnerabilities and red flags that I've identified that I think are applicable to the freight forwarders and most of you on the call is a freight forwarding company is listed as a product's final end destination. That is one of the most common ones that you'll have CBP and agents driving full speed to your office to say, why on earth are you exporting to a freight forwarder? Clearly, they're not the end user 99% of the time of that. And this happens in the UAE all the time, Hong Kong, and now we're seeing it more in Mexico and Canada, where they're going to freight forwarders in those destinations. Clearly, it's going on from them and being re-exported to another location. So that's a huge, huge red flag. The omission of destination control statements, that's more typically, you'll see that by industry, they're not putting it on there. Not complying with administrative subpoenas. So you'll typically get an administrative subpoena from an OEE agent. It can be signed by the SAC, the ASAC, the Assistant Special Agent in Charge, or the agents themselves. They have subpoena authority. And they will typically issue that to you requesting specific information in a specific time frame. Sometimes it's done by customer, sometimes it's done by country, sometimes it's done by commodity, and sometimes it'll be completely vague and cover a 5-year period because they don't want you to know specifically what is being looked at, and that's for the protection of the investigation and the parties involved. So when you get that administrative subpoena, obviously you want to comply. Feel free to consult with your attorney or consult with me as a middleman with the office, but do so respectfully. The ones that don't comply or are very abrasive and confrontational, you're typically going to get a lot more visits from that field office because that's raising red flags to them. But do your due diligence, comply with the subpoena. It can ultimately be enforced, especially if they're grand jury subpoenas, then you must comply. Those are issued by the Department of Justice. But you're going to see subpoenas. And typically in a BIS subpoena, it'll say, you must appear before. Don't panic. That's typically not the case. It's standard language in the subpoena. They're looking for documents, and you can put it on a thumb drive. You can email it as a password protected attachment. You can mail hard copies. But because of that 5-year retention rule, you better be able to get the stuff. It's typically 30-day turnaround time, I would say. But through me or through Peter or another firm, you can narrow the scope down and obviously sometimes get extensions if you need more time. But that's the importance of keeping your 5-year record requirement intact and being able to access those documents. Reliance on outdated classifications, that one's obvious. You know, this is the classification we got in the 90s. Does it still apply? And you're never coming for a modernized update on your commodity. Freight forwarder is listed as a principal party of interest. Boy, oh boy, if you're a freight forwarder doing that, you know, God bless you, because you are now taking on all the liability for that transaction. If you are listed as the PPI on the EEI, I love the acronyms, you are now going to be the main focus of any inquiry regarding that transaction. So if you are doing it for someone or a routed transaction or so forth, please have a power of attorney, please have that permission, please have all your documents in order that you are authorized to do that. Because as you see in the next one, well, my freight forwarder does that for me. I can't even tell you how many times we've gone to companies, my freight forwarder handles all that. Well, that to me, you're the finger's being pointed at you, freight forwarders. The finger is being pointed at you by the company. Well, my freight forwarder does that. Then we go out there and visit the freight forwarder and say, well, they told us you do it. No, we just go by what the company says. So now all this finger pointing is going on and everybody becomes liable or culpable. So just be aware of that. So let's see, Alicia, TSA does not allow the USPPI to do it. Okay, well that's good news. But I can tell you it still happens, and it might be more in a criminal aspect too. I mean, you guys on this webinar want to do it right, but you know, where you're still seeing it happen, and that might be what would be the error. You're not supposed to list the freight forwarder, and they do. So it could be input wrong. But all right, next slide. Some more red flags that I come across: the customer or the address is similar to one of the parties in one of the lists. That's why you have to check them. The customer or purchasing agent is reluctant to offer information on the end use, and industry and freight forwarders, you know, all the time inquire, and the customer doesn't want to tell you. That's when you pick up the phone and you call the local office and say, hey, something's fishy about this export. I have it here. If you want to come do an inspection, look into it. Something isn't right.
So Rob, let me ask you this.
Yeah.
Now that you are not with the government, but are
Yes.
a private person, if a freight forwarder, exporter feels something suspicious, but they don't want to call the government, can they call you and you can sort of guide them?
Yes, and I actually encourage that. Here's the thing. I'm a private citizen. I know some of you are thinking, oh man, I don't trust Rob. He's a government guy. He's going to go tell his buddies what's wrong. That's not the case. I'm here now to service industry, and I would be an unbelievable bridge to that law enforcement office, because if I didn't hire everyone, I know everyone. And typically, you know, if you have an attorney do it, that's absolutely fine too, but it's going to become a lot more formalized versus maybe the initial inquiry say, hey, listen, I don't want to deal with the office, really. I don't feel comfortable dealing with them. Here, you know, Rob, do you mind, you know, what do you think I should do? You know, I'm glad to help out on that type of stuff, but I also will help you develop those relationships with the agents, and that way you can go directly to them. And I'll have a number at the very end. There's an anonymous phone number that's checked daily by our headquarters, and you could report anonymously violations. I've seen companies who couldn't for the life of them get their high-level CEOs to help the export team and the managers down there do it right, because they, you know, it was all about the money. And they have called anonymously and said, hey, listen, we need an agent to come here and do an outreach and visit us because they're not doing it right, and we're the ones going to be liable. Because that's what we do. Who did the paperwork? Who filled this out? That's who I want to talk to. Why did you put this? Who told you to do that? Who, what, where, when, why? And it's going to come to all the freight forwarders and the businesses alike. So just be prepared. You know, I'm not trying to terrify you guys. I'm just trying to prepare you guys that, you know, this is typically what will happen. You know, we investigate thoroughly. So, okay, we got a few minutes left. Let me get to the case examples. All right, inspections. This is a very common one for freight forwarders, false statements. And I brought that up in the in the administrative violations. So you'll see very, very common types of false statements. Statements on the EEI. Again, you can get false statements there, or not filing properly in AES, which Peter mentioned. AES filings statements that the exporter does not require a license when in fact it does. False item valuations, which we'll get into that in a minute, and statements that an export shipment was for a particular license and in fact it was a different license item. Those are very, very common. I did the red arrow because I want you to see in each of these pictures, that's me climbing up into the container. And it was always my practice. I never sat behind the desk. If I expected CBP and my agents to get out there and inspect for the goods, we were going to help CBP or whatever other agency it was, and we were going to provide additional manpower to help. Next slide. Routine and law enforcement inspections. There I am again. There's my good buddy from CBP. We got HSI in the back corner there and ATF just off the screen. We had routine. We gone out to the Port Everglades and we opened some containers and we just started looking through them based on manifests, EEI information. It's screened by our intelligence officers. And we go out and we start popping containers and looking for stuff. Next slide. Intel. So here you go. There's a picture of a car battery in the upper left corner. We had some intelligence that guns are being exported out of a particular shipment. It was very good intelligence. We got with our law enforcement partners. We found the shipment of car batteries. We popped them open, and then you can see in the bottom left corner, full of bullets. These are standard, run-of-the-mill big box store car batteries you'd buy. They emptied out the cells and filled them with batteries, and then other ones were full of guns. So that's another thing I'll add real quick is firearms. Firearms now are in the jurisdiction of commerce. If it's not a 50 caliber military type machine gun attached to a Humvee, it is controlled by Department of Commerce now. So we work routinely with ATF. All gun controls are now under the classification and regulation of Department of Commerce. So we're going to see tons and tons of cases jointly with ATF, and they're already going on. Next slide. Industry inspections. Here we have a freight forwarder. Every single day of his business, every day of the year, this gentleman dealt with laundry detergent. He's been lifting these same boxes over and over, countless times, and something just felt off about some of the other boxes. They were heavier, and something was just off. He opened one of them, and to find the paperwork specifically, and he's like, you know what? All of these are heavier. He weighed them, and he called up. He called up OEE. They called up ATF. Said, sure, we'll come down to an inspection. Not a problem. We went down there again. Of course, they inspected, opened them all up, and there you go, deep buried inside the soap, handgun after handgun after handgun with all the serial numbers filed off. So that was one where an actual observant freight forwarder came and helped catch these guys. Next slide. This is FedEx. There I am again leading the team. We're doing a massive FedEx operation where FedEx, huge company, exported licensable stuff to an entity without the proper license and paid $500,000 in civil penalties. Let's say FedEx says, fine, I paid $500,000, but I made $500 million. Again, we could come in and deny export privileges. This case went on for years and years back and forth, but it's not singled out, small or large company. Everyone is liable and culpable. Next slide. All right, this is the last section. This was a 7 to 8 year investigation that myself and one of my other agents worked out of Sarasota, Florida, called Access USA, and former owner Eric Bayard. That's their facility and their giant warehouse. Think of them as a humongous freight forwarder / mini Amazon. Next slide. This is their warehouse where they would ship all their documents out of. Huge place, huge warehouse up there in Sarasota. And this resulted out of just a routine trip out to the field by HSI and one of the OEE agents just to learn about the company and figure out what they do and provide educational outreach information. Next slide. There's Mr. Bayard, happy owner, sitting on his boxes. That box, not literally, but in most cases, it would be full of cash or, padding his bank account. He was extremely wealthy individual in Sarasota, Florida. And that was, I think, the cover shot for Entrepreneur magazine. Fast forward to the next slide, and a couple years later, there's Mr. Baird again. Former CEO pleads guilty to export violations. Unbelievable scheme that this gentleman did to circumvent export regulations and bypass everything that went on as far as requiring the EEI. So if you go to the next slide, I'll go over the scheme. Actually, this is just an example of the charging letter, and Peter had some of those too. He was charged with 166 counts causing, aiding, and abetting a violation. This is just the administrative portion. And it's only 166, and that was one sample of 1 month of 1 year, and he was doing it for 10 years. So we could have had tens of thousands of violations at $300,000 each. I mean, that technically what it could have been. So that just kind of shows you, we stopped at 166 because we couldn't, we were there. Our chief counsel was overwhelmed. The amount of information was overwhelming. But if you go to the next slide, here's what they did. So Access USA, it's a Florida-based packaging forwarding company in Sarasota. And they would provide a physical address, or they called it a suite. And it was really just a designated space on it. You saw those shelves in the picture. It was a designated space on that shelf. And they would provide foreign customers with an address. And then those foreign customers were able to purchase stuff, what was believed to be domestic, when in reality it was being exported. So the company would receive the goods based on that address, or they would buy them and send them to Access. Access would then repackage them, rename them, relabel them, and then export them on undervalued amounts. Let's say they would call it a different item, or they would undervalue it so it wouldn't trigger any scrutiny. And they then started a personal shopper program where they would actually have employees buy the items for the foreign customers, use credit cards, and the owner would get them credit cards and tell them they can keep the points and buy stuff at all, millions of points, PayPal accounts. They'd have stuff delivered to their home address, bring it into that facility, package it up, and export it for the foreign customer. Tack on misdescribing and undervaluing, falsifying the export documents, destroying the export documents, and then maintaining almost zero records. So here we are, 60 to 70 federal agents show up to conduct a search warrant on this company, Access USA. I think it was a Monday or Tuesday. I was leading the operation. That Friday before, I believe it was, a group of investors had bought Access USA from Eric Baird for hundreds of millions of dollars based on the valuation and all this illegal activity they didn't know about because they actually did poor due diligence in the purchase. We raid them on Monday. They're smoking cigars on Friday. We raid them on Monday. And they thought it was like from that famous MTV show Punk'd, like what's the big joke here? Then all of a sudden, everybody turns white. The entire team shows up. The CEO shows up. The owner shows up, and it was real. And it got real really fast. And the company had some extensive successor liability penalties put on them. If you see the next page, and this will be essentially the last one, this is what happened to the individual, and this is what happened to the company. So he pled to one felony count of smuggling, and that was just to great negotiations and stuff between the attorneys for him to only get that one count. But there's no way he was going to plead to, at the time, an IEPA charge, because that was 20 years. So they chose smuggling. He paid $17 million in monetary fines out of pocket. Now, mind you, he made hundreds of millions in the transaction, so I don't feel bad for the guy. And then $7 million was suspended, and then again the exports. This was the highest civil penalty ever in the history of BIS imposed on an individual. So again, a lot of people are used to companies being the target, and the company goes down and they reinvent themselves and so forth. No, they're holding CEOs, they're holding employees, they're holding export managers, they're holding freight forwarders, individuals responsible for all this. Access, the poor guys, they ended up paying this $27 million also, had 17 suspended, so each both potentially paid $10 million, and had all those other counts 3 days, one weekend after buying the company, because this Mr. Bayer guy was so good at his deceit in his program, and he didn't divulge any of it to the buyers.
One point of emphasis that you mentioned, people forget, if the exporter or the violator is the company, a penalty can be assessed and will be assessed about any individual involved, whether it's a manager, the vice president of compliance, or exports, up to the president. And when the penalty is assessed against an individual and they have to pay that penalty to BIS, they cannot be reimbursed by the company.
Right. And a lot of times they don't fall under the umbrella of the corporate attorneys either. They're getting their own attorneys, having to defend themselves. It'll cost, tons and tons of money, but at the end of the day, the individuals and the company collectively can be targets. All right, quick takeaways. I know we're short on time, and then I'll follow up. I think there were a couple questions that came in there, but again, keep your records for 5 years. Be aware of the diversion risk. Check those lists for sure. Do all the due diligence you can when it relates to those red flags. If you're going to be the PPI, have that power of attorney, or if you're going to do anything representing a company, have the power of attorney. It's there to protect you, and just try and get that as often as possible. As you can see from the last case, do not undervalue the commodities. That's what they hit Mr. Bayer with in Access, because it was the simplest thing to do. Do not undervalue. Do not change the value under any circumstances for the client, period. Voluntary self-disclose as often as you can, because it's going to be a great mitigating factor and probably will result in a warning letter. And then if you anonymously want to report stuff where, hey, I'm a small freight forwarder and this big time freight forwarder is right next door and they're doing everything illegal, I'm doing everything by the book, they're making so much more money than me, there's a way to anonymously report that. And it is truly anonymous, and it goes to a hotline that's checked by someone at headquarters every day, and that then is farmed out to whatever field office it pertains to. And then most importantly, contact Peter or myself with any questions, and I'm at your disposal. I'm for hire, and I'm available. And the next slide is my contact information if you didn't get it in the beginning. But please, thank you again for this opportunity. I tried to jam 23 years into a few slides, but I'm available. I live up in Boca Raton area, so I'm easily accessible anywhere in Florida. And again, thank you for your time.
Awesome. Thanks so much, Rob. That's pretty incredible. I have 1,000 questions in my head, but we have one from League Day asking, and this is something that's come up in a couple of different cases, but what happens when the US PPI doesn't want to fill out the SLI correctly? As freight forwarders, we know that the product needs an ECCN and maybe a license. How do you deal with that?
You put it back on the company. And frankly, I would do it in an email. The following items are required by you in order for this transaction to take place. If you guess, gamble, or get it wrong, they're pointing the finger at you, or they're going to have that email that said, I told my freight forwarder to do it. I wouldn't do it. It's not, is it worth, you got to ask yourself, is it worth $300,000? Or is it worth a warning letter? Or is it worth bad publicity for my company if I did it wrong? Is it worth the attention of the government? It's to me, it's not. That's a red flag in itself, if they're just refusing, any part of it. They should be the most forthcoming of all this. This is their commodity. If they're doing it right, everyone on this call wants to do it right. That's why you're on the call. I would have the same expectations from your clients.
Right. So I hear this all the time. The exporter would say to the freight forwarder, I've been doing it this way for 20 years. It's never been a problem. I never needed a license before. Why are you hassling me now? If the freight forwarder knows what it's doing and it's a credible, legitimate company, it should follow the rules and educate the exporter about those rules. And if is asked to do something improper, then it's not worth it. Just like Rob said, it's just not worth it.
Okay. What else, guys? Like Peter said at the beginning, this is an hour of free advice. So
actually, Rob is more valuable than me. He's fine.
So what I do want to reiterate too is that relationship with the office. The Access UA portion, $27 million, all those fines, penalties, denials. I was ready to give them a warning letter. I was ready to give them a warning letter if they just took the time to meet with the agent, discuss what was going on, even with their attorneys. I wasn't after them because I knew they had bought this company. They were duped, but boy, they hunkered in and they denied. And it's not our fault. And look what happened. So there, I read all 56 pages of the export compliance manual they have there on the BIS website. Not one line on one page that I find anywhere develop a relationship with the agents in your AOR. So I want to be that caveat for you guys. I want to be that bridge, and I want to be able to, if you want me to facilitate them come in your office, I'm glad to help. If you want me to be there when they're there, so I can wink and say, this is legit, or I can do what I would like to do too, is I would like to come down and do almost like a mock outreach or a mock, inspection, and kind of show you what it's like, if they come up. It'll be probably so routine for you. And again, there's no liability. I would at that point be working and employed by you. I'm more than happy to come down and do those reviews for you and create that compliance and risk assessment analysis. And then I'll come up with some solutions and work with you guys. So it's something I can offer.
Awesome. That's pretty cool. Guys, feel free to turn your microphones on and participate in the conversation. We set it up as interactive today on purpose. But Rob, I just wanted to ask a question about the laundry detergent case with the guns and the laundry detergent. Had the forwarder actually started investigating or touching the cargo on his own, what would have happened?
This particular guy was very experienced or well-versed in a lot of this stuff. Essentially, when I think I mentioned he opened it, that wasn't the case. He was opening to get the information out in order to provide it to the agents. We typically, in fact, I might have to defer that to the forwarders online, but we typically don't see the forwarders doing that type of inspection on their own. It's typically a call to our office or CBP, but I'll defer to Peter or you guys online. If do you typically do that? Because we do it based on phone calls to us. Please come check the suspicious package, or we show up because we find it on our own.
It would be unusual for a forwarder to open cargo from its client exporter.
Right.
I mean,
at the first suspicion, that's when the call needs to be made.
Yeah, it's you make the call. Something's not right. Believe me, the agents love to go out and do those inspections because they now are developing relationships with you. They have a contact. They'll probably do an outreach. Now, I don't want you to panic when agents come out and do an educational outreach. That I know there's always been the fear of, okay, now they're imputing knowledge on you and they're going to hold it against you forever and ever. Technically, yes, they're imputing knowledge on you, but they do have, and I can vouch for this, we do have a metrics where we have a certain amount of educational requirements that we have to make with industry. So a lot of them are very, very just routine. They're not out there targeting you as freight forwarders. They'll typically go down to Miami, and you could pick any warehouse district and find 8 freight forwarders in a row, and they'll just go down all 8, and that way they've done 8 outreaches for the month, and met sort of the metrics and requirement of their performance evaluations. So don't be scared to death when they show up to say it's for an outreach. But I would appoint somebody, anyone in your companies, appoint a point of contact for your exports. So when somebody shows up inquiring about exports, you don't have to randomly pick whoever did it. Like, make somebody a centralized point of contact when it comes to export inquiries, so that they can go to that one person, and that person can then go to the other people within the company to identify further any other needs. Awesome. But that would help so much when we show up to companies like, yep, Miss X or Mr. Y is head of exports. Let me put in touch with them, or they're not here today, or they'll email you with an appointment, something like that. To have that one point of contact is going to help you guys tremendously.
I like it. I think that's really good advice. Guys, if you've been on the call today, I know some of your colleagues had registered and they let me know ahead of time that they couldn't make it live. So we will be sharing the recording. Peter's slides will also be coming across to you, but make sure you note Rob's contact information. I know we had it up. I will send it back to you in an email as well, so that if you have any questions, if you have needs, don't hesitate to just ask these guys before you go down the wrong path. That's why we provide these for you guys and help you connect and start building these relationships with the experts to get you through the hurdles that you need to conquer. It's all about, at the end of the day, we want safe and secure trade in and out of the country. And these are our advocates. And Peter, Rob, thank you so much.
Welcome. Thank you for having me, for sure. Hopefully it was helpful.
Absolutely. Absolutely. Guys, I hope you have a great rest of the day, a great weekend, and we'll see you all soon.
Thank you
Okay?
very much. Take care.
Thank you
Bye-bye.
so much. Likewise to everybody. Thank you.
Thank you very much.
Bye-bye.
Thank you. Have a good day.
Yeah, look.
Thank you.
So Meg.